Good afternoon. My name is Tori Trotta, and I'm the Associate Dean for Information Technology and the Ross Blakely Law Library. And it is my pleasure to welcome you here today to the Sandra Day O'Connor College of Law as we celebrate Constitution Day. And we're very happy that you're here. We have two wonderful speakers planned for you this afternoon, and we promise that they will both be very interesting and, in some cases, downright entertaining. Today's program is the official Arizona State University Constitution Day program, and it is sponsored by the university libraries and the Ross Blakely Law Library. And before I go any further, I would like to introduce and thank several people for their work on this project. First of all, I want to introduce and thank Mr. Brad Vogus, who is Head of Social Sciences and Government Document Services of ASU Libraries. There he is right there. He's passing out many copies of the Constitution, so if you didn't get one from him. It's a cool format. I would also like to introduce and thank our wonderful technical support, which includes Ms. Lori Ralston, who is the Director of IT here at the Sandra Day O'Connor College of Law, and Mr. Matt Harp from University Libraries, who is taking care of the video for podcasting today. And we have Fred also here, who where did he go? Oh, he's gone, the secret. We have a lot of tech people here, and we're grateful for all of their work in getting this up on the web for other people who can't be here. And lastly, I would like to thank Judith Nichols of the Sandra Day O'Connor College of Law Development Office, and also Jennifer Duvernay of the University Libraries Marketing Department for all they did to get the word out about our wonderful program. Today marks the 222nd anniversary of formal approval of the Constitution of the United States. It is not simply the oldest major governmental constitution embodied in a single document, but even with its 27 amendments, it is the shortest. It is 7,591 words long, including amendments, and unlike many state constitutions, it is a document that you can carry around in your pocket. It is a document that orders our government, our laws, and therefore many of the aspects of our lives. Acres of books have been written about some aspect of the Constitution, about the justices that interpret it. Countless scholars have written about it and devoted their lives to understanding of it, and lawyers always study it in pursuit of solving legal problems within its boundaries. No matter how much you think you know about the Constitution and its operation, there is always more that you can learn. We thank you so much for attending today and think you will enjoy the program. Our first speaker today is visiting Professor Andy Hessick. Professor Hessick is a graduate of Yale Law School and served as a law clerk for Judge Raymond Randolph of the United States Court of Appeals for the D.C. Circuit and for Judge Reena Raggi of the Second U.S. Circuit Court of Appeals. After spending a year as a Bristow Fellow in the Office of the Solicitor General for the United States, working on a number of cases before the court, Hessick joined the law firm of Kellogg, Huber, Hansen, Todd, Evans, and Figel in Washington, D.C. He is the author of 2 law review articles, Plea Bargaining and Convicting the Innocent, The Law of the Prosecutor, the Defense Counsel, and the Judge, and The Federalization of Airport Security, Privacy Implications. Both of these law journal articles are on the publications table in the back. We entitled this first session, The Constitution in Action. Today, Professor Hessick will address us on a number of the more interesting cases that the United States Supreme Court will have before it in its term that begins next month. Please join me in welcoming Professor Andy Hessick.
Thank you. Thank you very much. I was going to start this talk today with a description of the various dimensions of the Constitution, the number of words, number of amendments, things like that, how we have the smallest Constitution. But I'm glad I'm not doing that since you already heard all of that. Instead, my talk today is going to focus on the cases in the Supreme Court this term discussing the Constitution. The Constitution is the cornerstone of our federal government. It establishes the 3 branches of government, lists each branch's powers, and enumerates various rights. In some places, such as the sections describing the election of the president and the transfer of power should the president be incapacitated, the Constitution gives detailed procedures. But these are the rare exception. Many provisions in the Constitution are broadly phrased. The details of these provisions have been filled in by the courts, and in particular the Supreme Court, in decisions interpreting the Constitution. Since the early 19th century, the Supreme Court has been understood to have the final word on the meaning of the Constitution. And over the last 2 centuries, the court has issued thousands of decisions interpreting the Constitution. These interpretations are based not so much on the text, the very reason that the interpretations are required is that the text is ambiguous, but on other considerations, such as history, policy, and precedent. And although they are nowhere to be found in the Constitution's text, these interpretations are treated as part of the Constitution itself. Now, today I'm going to talk about the constitutional cases on the Supreme Court's docket. So far this term, the court has granted review in 28 cases, and of those, 9 directly present a constitutional question. 9 out of 20 is actually quite a higher proportion. Although it has the final word on the Constitution, the court historically hears relatively few cases explicitly presenting constitutional questions. Most of the cases on the court's docket present other issues, such as questions of statutory interpretation. Of course, even in those statutory interpretation questions, the Constitution often lurks in the background. Preemption is a good example. Known for arising only in the context of extremely complex, detailed federal statutes with long, cumbersome names, the preemption doctrine deals with situations when state law and federal law conflict with each other. When state law and federal law are inconsistent, federal law trumps. It preempts state law. Whether a federal law conflicts with, and therefore preempts, state law depends on the text of the federal statute. In other words, it is a question of statutory interpretation. Although preemption cases focus almost exclusively on the text of federal statutes, the preemption doctrine itself derives from the Constitution. Federal law can preempt state law only because of the Supremacy Clause, found in Article 6 of the Constitution, which says that the Constitution, the laws of the United States, and treaties shall be the supreme law of the land. Because federal law is supreme, it displaces state law whenever the two conflict. The court has granted certiorari in 2 preemption cases so far this term. In Roe versus New Hampshire Motor Transportation Association, the court will consider whether the Federal Aviation Administration Authorization Act, the long cumbersome name, preempts states from regulating carriers that deliver contraband to children. In Regal versus Medtronic Incorporation, the question is whether the medical device amendments to the Food, Drug, Cosmetic Act, again the long name, preempts state law claims seeking damages for injuries caused by medical devices that received approval from the FDA before they were released on the market. Now, it's obvious the Constitution is not mentioned in these questions, nor is it even likely that the Constitution will be mentioned in the court's decisions in these cases. But the Constitution is lurking in the background as a critical component of the case. I want to focus more today, just for time considerations if nothing else, more on those cases where the court has explicitly been called upon to interpret the Constitution. It is in these cases that the court is likely to change the scope and meaning of the Constitution through its interpretations. In past cases, the court's interpretation of the Constitution has sometimes resulted in the contraction of the Constitution's text. The First Amendment, for example, provides that Congress shall make no law abridging the freedom of speech. Now, no law, one would think, means no law. But that is not what the court has said. It is often stated that Congress can enact a law restricting the freedom of speech if that law is necessary to fulfill a compelling government interest. In other words, the government can always violate the freedom of speech, so long as it really needs to. Other times, the court has expanded the Constitution's text. One famous example of this phenomenon is Miranda versus Arizona. In Miranda, the court held that before questioning a suspect in custody, police must warn him of the right to remain silent and the right to an attorney. Failure to administer these warnings may result in the suppression at trial of statements made by the suspect while he was in custody. The court derived the rule from the Fifth Amendment, which provides that no person shall be compelled in any criminal case to be a witness against himself. Miranda is a pretty far stretch of this text. Nothing in the Fifth Amendment requires the police to administer warnings at the station house. It provides only that a person can't be compelled to testify against himself at trial. The court, in fact, has acknowledged this stating that Miranda is just a prophylactic rule, though a constitutional one. Another area where the court has expanded the Constitution is the Commerce Clause. Article 1 of the Constitution empowers Congress to regulate commerce among the states. The clause is phrased as a positive grant of authority to Congress. But the Supreme Court has held that this positive grant also contains a negative component prohibiting the states from interfering with interstate commerce. This is the so-called Dormant Commerce Clause. Of course, all sorts of state laws interfere at some level with interstate commerce. A state law limiting the speed limit to 55 miles per hour on highways instead of 65 slows down interstate commerce to some degree. The Supreme Court, therefore, has limited the scope of the Dormant Commerce Clause doctrine. One situation where the court has traditionally applied the doctrine is when a state law discriminates on its face against out-of-state entities. Such laws, the court has said, are virtually per se unconstitutional. Now, the court has never really given a satisfactory justification for the Dormant Commerce Clause doctrine, as is highlighted by the fact that the court has given different justifications for it over the years. It is therefore perhaps unsurprising that the court cut back on the scope of the doctrine last term in United Haulers Association versus Oneida Herkimer Solid Waste Management Authority. There, the court carved out an exception to the rule against discriminating against out-of-staters. It held that a state law can favor state-owned businesses over out-of-state businesses, so long as the state-owned business provides some traditional public function, such as processing trash or sewage. The court explained that the purpose of the Dormant Commerce Clause is to prevent economic discrimination against out-of-staters, and therefore, that the Dormant Commerce Clause has no application when the reason for discrimination is not economic, but to facilitate the provision of public services. Although Oneida Herkimer's reasoning appears to create a potentially broad exception to the Dormant Commerce Clause, the court's decision in Oneida Herkimer addressed only the specific situation where the government enacts a law favoring state-owned businesses providing public services over out-of-state privately owned businesses. It left open many questions about the scope of that public service exception. The court has decided to provide some clarity this term in Department of Revenue of Kentucky versus Davis. Under Kentucky's income tax laws, interest on bonds issued by Kentucky is not taxable income. But interest on bonds issued by other states is taxable income. A group of Kentucky taxpayers who earn interest on out-of-state bonds brought a Dormant Commerce Clause challenge to the Kentucky law. Although the Kentucky law discriminates not against out-of-state businesses, as in Oneida Herkimer, but against other states, Oneida Herkimer gives pretty good reason to think that the Supreme Court will uphold the law. The central point of Oneida Herkimer is that the Dormant Commerce Clause does not prohibit laws favoring state-owned businesses providing public services. Of course, in Davis, the case before the Supreme Court this term, the state law does not favor a state-owned business providing a public service. Instead, it favors state bonds. But Kentucky sells those bonds to fund public services. And giving a tax break on the bonds encourages the purchase of Kentucky bonds instead of bonds issued by other states. Under Oneida Herkimer, that may well be enough to sustain Kentucky's law. Aside from the curbing of the Dormant Commerce Clause doctrine, Davis is interesting because of how the votes are likely to break down. The Dormant Commerce Clause involves states' rights. And when it comes to states' rights, the Supreme Court ordinarily breaks down 5-4, along conservative and liberal lines. But in Oneida Herkimer, the vote was 6-3. The 6 consisted of Chief Justice Roberts and Justices Scalia, Souter, Thomas, Ginsburg, and Breyer. The dissenting 3 consisted of Justices Stevens, Kennedy, and Alito, not at all reflecting a division along ideological grounds. One explanation for this is that while the Dormant Commerce Clause does involve states' rights, it doesn't do so in the traditional way. Usually when we talk about states' rights, we're talking about states' rights with respect to the federal government. The dispute really is the question whether the federal government has the power to do something that affects the states. Overgeneralizing, conservatives tend to think that the federal government has limited power vis-a-vis the states, and liberals tend to think that the federal government has broader powers. But the Dormant Commerce Clause does not involve a question of federal versus state power. Everyone agrees that Congress has the power to regulate interstate commerce, and that if a state statute conflicts with such a congressional statute, the state statute must fall. The issue under the Dormant Commerce Clause is whether the states have the power to interfere with interstate commerce even in the absence of contrary federal legislation. So the traditional conservative and liberal views do not really apply. Another point of potential interest in Davis is that it may illustrate the different approaches to judging employed by Chief Justice Roberts and Justices Scalia and Thomas. Several times last term, Roberts, Scalia, and Thomas agreed on the outcome of a case, but they gave different reasons for the result. Roberts decided those cases by following or creating narrow exceptions to existing precedent. Justices Scalia and Thomas, by contrast, argued that the court should overrule precedent and adopt new, bright-line rules reflecting their views. That is precisely what happened in Oneida Herkimer. Roberts, the author of the principal opinion, created a narrow exception to the ban against discriminatory state laws. By contrast, Justice Thomas, and to a lesser extent Justice Scalia, advocated the abandonment of the Dormant Commerce Clause altogether. I expect we shall see a rehash of those positions in Davis. Another respect in which the Supreme Court has expanded the Constitution is by reading a right of association into the First Amendment, although, as I mentioned earlier, the court has contracted the First Amendment in other respects. This right of association, the Supreme Court has said, is the right for people to associate with others of the same political bent. That right of association is not found in the text of the First Amendment. The First Amendment states, in relevant part, that Congress shall make no law abridging the freedom of speech or the right of the people peaceably to assemble and to petition the government for a redress of grievances. By its terms, the amendment recognizes the right to speak, assemble, which means simply for the people to gather together, and petition the government. A right to association with like-minded individuals simply is not mentioned. Usually the recognition of an extratextual right generates some sort of outrage. But that is not so with the right to association, probably because just about everyone wants to be able to associate with people with whom they think the same way. In California Democratic Party v. Jones, the court explained that a corollary of the right to associate is the right not to associate. And from this, it held that members of political parties, and those members alone, have the right to determine their own membership and to pick their candidates in partisan primaries. Following Jones, Washington State implemented an open top two primary system instead of partisan primaries, where, for example, Republicans and Democrats separately select nominees. The Washington system permits all voters to vote on the same ballot during primaries, and the nominees for the general election are the two candidates who receive the most votes. But Washington's system is not completely nonpartisan. To provide voters with greater information, a candidate may express on the ballot a preference for a political party, even if he is not a member of that party. This term, and indeed it's the first case that the court will hear this term, the court will consider whether this system can be squared with Jones. According to the Democratic and Republican parties, it cannot. They claim that permitting a candidate to express a preference for a political party that has not nominated him unconstitutionally forces that political party to associate with the candidate. I may be wrong, but it seems to me that this challenge is unlikely to succeed. Permitting someone to say that he likes a particular party does not make him part of that party, much less its nominee. Certainly no associational rights would be violated if the state gave candidates space to write whatever they wanted and a candidate chose to write that he preferred a political party of which he was not a member. But I am in the minority in this view. Most pundits think that the court will strike down the Washington system. In any event, however the court decides the case, it is clear that the decision will not rest on the text of the Constitution, but on this extra-textual right. There's another First Amendment case that I want to discuss. It involves a special rule about the ability of a person to challenge the constitutionality of a statute based on its hypothetical applications. Usually, when a person seeks to challenge a law that has been constitutionally applied to him, he cannot challenge it on the ground that the law might be unconstitutionally applied against someone else. For example, if the government seizes a person's property after conducting a hearing, that person cannot challenge the seizure on the ground that it was made pursuant to a law that authorizes seizures without a hearing in violation of the Due Process Clause. Why? Because the person, in fact, received a hearing, and he therefore suffered no due process violation. The reason for this requirement is that courts are empowered only to decide cases before them, and separation of powers concerns prohibit courts from reaching out to strike down a law based on a hypothetical case not before them. The Supreme Court, however, has made an exception in the First Amendment context. This is known as the Overbreadth doctrine. Under that doctrine, a person can challenge a law that was constitutionally applied to him on the theory that it might be unconstitutionally applied against someone else. If the law prohibits a substantial amount of constitutionally protected speech, then the law is invalid on its face, even if it could be constitutionally applied to the challenger. The doctrine rests on the assumption that if a statute could not be challenged for overbreadth, people not before the courts would refrain from exercising their First Amendment rights. In 2002, the court considered an overbreadth challenge to the Federal Child Pornography Prevention Act. The act, as its name suggests, was designed to prevent the dissemination of child pornography. To accomplish that goal, the act banned not only actual child pornography, it also banned material that was advertised as depicting child pornography, even if the material did not in fact depict minors. In Ashcroft versus Free Speech Coalition, the court held that this law was unconstitutionally overbroad. Although the court said that the possession of child pornography is not constitutionally protected, the court explained that the act outlawed a substantial amount of conduct that is protected by the First Amendment. In particular, the court noted that under the act, a person could be held criminally liable for possessing material that had some time in the past been advertised as depicting child pornography, even if, one, the material did not in fact depict child pornography, and two, the person possessing it did not even think that it depicted child pornography. Following this decision, Congress tried to address the court's concerns by enacting the PROTECT Act. Unlike the earlier Child Pornography Prevention Act, the PROTECT Act does not criminalize possession of material that is advertised as child pornography. Instead, the act criminalizes the act of advertising or describing material as child pornography, or even using descriptive terms suggesting child pornography, even if the advertiser does not possess any pornography at all. The constitutionality of this provision is the question before the court this term in United States versus Williams. Williams was arrested and eventually convicted for posting a link online to pictures that he described as child pornography. Turns out, the pictures posted by Williams were, in fact, child pornography. So the PROTECT Act was constitutionally applied to him. Williams argues, however, that his conviction should be reversed on the ground that the law is overbroad, because it outlaws a substantial amount of conduct that is protected under the First Amendment. Williams argues, for example, that since all the act requires is that a person use a description suggesting child pornography, the act outlaws such protected conduct as the use of a wholly innocent yet suggestive titles. For example, a posting entitled, "Good Pics of Kids in Bed," sent by the grandparents. It is hard to say whether the Supreme Court will think that the PROTECT Act is unconstitutionally overbroad. At least part of the problem is the fuzziness of the overbreadth standard. Recall that a statute is not unconstitutional if it outlaws some protected activity. Rather, for a statute to be unconstitutionally overbroad, a substantial portion of the activity prohibited by the statute must be protected speech. How does one determine if the overbreadth of a statute is substantial? There are no clearly defined standards. None saying, for example, that a law is constitutional only if less than, say, 25% of the conduct it outlaws is protected. And even if there were such a standard, the court would in all likelihood lack the data necessary to determine whether that standard was met. The court does not have statistics on the number of people who engage in protected conduct that is outlawed by the act. Moreover, even if they did, the court almost certainly lacks the ability to imagine all the types of protected conduct that the statutes might outlaw. Given the virtually standardless nature of the Overbreadth doctrine, plus its uneasy tension with separation of powers, one might expect at least some justice to seek the abolition of the doctrine. But that hasn't happened. All the justices have endorsed the doctrine at some point or another. Moreover, one can't help but suspect that the lack of standards presents an opportunity for decisions based on considerations other than the law. In past cases presenting similar challenges to other laws targeting pornography, justices strongly opposed to pornography have generally voted to uphold such laws, while those less scandalized by pornography have tended to think that such laws are unconstitutional. Moving on to something completely different. No talk about the Supreme Court's recent terms or its upcoming term would be complete without a discussion of the cases involving the president's power. The Guantanamo cases are the most famous, but one such case that I want to talk about now this term is Medellin versus Texas. Jose Medellin, a Mexican national, was sentenced to death in Texas state court for murdering 2 women in Texas. After that conviction was affirmed on appeal, Medellin filed a petition for habeas corpus in state court. In that petition, Medellin argued for the first time that Texas had violated his right under the Vienna Convention on Consular Relations, a treaty to which the United States is a party. Medellin claimed that the convention required Texas to notify him of his right to inform the Mexican consulate of his arrest, but that Texas did not do so. The Texas state courts denied the petition. Medellin's subsequent petition to the United States courts was also denied. Meanwhile, however, Mexico filed a claim in the International Court of Justice, the ICJ. That's the court charged with interpreting the Vienna Convention. Mexico argued that the United States had violated Medellin's Vienna Convention rights by failing to advise him of his right to contact his consular office. The ICJ agreed. To remedy the violation, the ICJ ordered the United States to, quote, review and reconsider Medellin's conviction. Just about everyone agrees that the rulings of the ICJ do not bind the United States. Following the ICJ's decision, however, the President of the United States issued a memorandum giving effect to the decision of the ICJ by directing the Texas courts to review and reconsider Medellin's conviction. The Texas courts, however, refused to do so, essentially on the ground that the President has no business telling the states how to run their courts. Now before the Supreme Court, the case raises a number of interesting issues regarding the intersection of federalism and the President's power to control foreign policy. One question is whether the President has the power to issue a unilateral directive in an effort to enforce the ICJ decision. The President does have the power to create laws through his authority to implement the government's foreign policy. But he traditionally does so through agreements with other countries, such as treaties or executive agreements. In Medellin's case, however, the President did not form an agreement. He acted unilaterally, and that, according to Texas, is beyond his power. Now, this is a clever argument, but I suspect that is likely to fail. Although the President does ordinarily pursue international policy through agreements with other nations, the President has on occasion enforced pre-existing treaties through unilateral executive orders, and the court has upheld those orders. For example, to end the hostage situation in Iran, the President and Iran entered into an agreement providing that, in exchange for the release of the U.S. hostages, all claims by United States citizens against Iran would be terminated. And the President subsequently issued a unilateral executive order barring the transfer of Iranian funds in the United States. And the court upheld that order as a valid means of enforcing the agreement with Iran. Here, in Medellin's case, the court may well view the president's memo as simply a unilateral action designed to implement a past agreement, namely the Vienna Convention. Perhaps a more interesting argument, though, is that the president's memo impermissibly commandeers the state courts. Although state courts are required to enforce federal laws, even if those laws conflict with state procedural rules, they must do so only to the extent that they have jurisdiction. As the Supreme Court has explained, the requirement that a state court of competent jurisdiction treat federal law as the law of the land does not necessarily include within it a requirement that the state create a court competent to hear the case in which the federal claim is presented. Now, Texas argues that the reason its court refused to hear Medellin's claim is that the court lacked jurisdiction because Medellin failed to raise his Vienna Convention claim in a timely manner. He didn't do it until his habeas petition. He didn't do it during the criminal trial. Thus, Texas claims the president exceeded his power by directing Texas to hear the claim. But it's really not clear that Medellin's default is jurisdictional, so far as I can tell. Texas cases have been ambiguous at best, whether default is jurisdictional or procedural. And the word jurisdiction certainly appears nowhere in the lower Texas court's opinion in Medellin. The other major foreign powers case this term is Boumediene versus Bush, the latest in the Guantanamo detainees case. As you probably know, the United States detains in Guantanamo a number of people that have been determined to be enemy combatants. Several of those detained have sought their release by filing a petition for writ of habeas corpus. Many people, including some in Congress and the president, thought the federal courts lacked jurisdiction over these petitions. But in 2004, in a decision called Rasul versus Bush, the Supreme Court ruled otherwise. In response, Congress enacted the Military Commissions Act, which stripped federal courts of jurisdiction over habeas petitions filed by enemy combatants detained at Guantanamo. The questions before the Supreme Court this term, in that case, are whether that act does clearly remove federal jurisdiction of such claims, and if so, whether that act violates the suspension clause, which provides that Congress cannot suspend habeas corpus except in times of rebellion or invasion. No one disputes that this is a very important case, but I can't give you my thoughts on the matter because I clerked for one of the judges while he worked on the case below. But while I can't talk about the most important case already granted this term, there is a more important case, a case that I think is likely to push Boumediene to the sidelines, that the court has not yet decided whether to review. And I can talk about that case. It is a case arising out of Washington, D.C. that has generated lots of controversy. Dick Heller lives in a high-crime neighborhood in D.C., and he sought to keep a handgun in his house for protection. Heller was unable to do so, however, because of D.C.'s strict laws prohibiting the registration and thus the possession of handguns. Heller, along with 5 other D.C. residents, subsequently challenged this restriction as unconstitutional under the Second Amendment. The Second Amendment provides a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Needless to say, just from my reading it, the amendment is not a model of clarity. Pointing to the introductory clause about militias, most courts have concluded that the purpose of the amendment was to ensure the state's abilities to maintain a militia, not to grant each individual the ability to keep a gun. Thus, they have said, the amendment provides a right for individuals to bear arms only to the extent necessary to support a functioning state militia. In Heller's case, however, the D.C. Circuit held otherwise. It concluded that the Second Amendment grants individuals the right to bear arms regardless of militias. It therefore struck down D.C. Circuit's handgun restrictions. D.C. has now sought review in the Supreme Court, and I think chances are good that the Supreme Court will grant it. The decision creates a split in the circuits about an important issue. Moreover, the decision strikes down a law, and not just any law, but a law that is quasi-federal, as all D.C. laws are. And I think it does not hurt that the justices have a sense that they could be impacted by the law because they live and work inside of DC. As for the outcome, I can't imagine the court upholding the DC Circuit's decisions. I would guess that most of the justices will avoid clearly resolving the question whether the Second Amendment confers rights on individuals or states, and just take the view that even if the Second Amendment does confer rights on individuals to bear arms, it does so only to the extent that the state says those arms are necessary for militia service. But it will be interesting to see whether any justices decides the case on the ground that the point of the Second Amendment is to prevent federal interference with state militias, and therefore the amendment poses no bar to federal firearm regulations in DC or other federal territories, that the federal government has plenary power in those areas when it comes to guns. And while I can't say precisely what reasoning the court will use, I am confident in saying that the court's decision is almost certain to focus not on the text of the Second Amendment, but more on its history and its purpose, as well as certainly the current problems that we experience with gun crimes. And yet, although it will be driven by considerations other than the text, the court's decision will become the definitive understanding of the text. Thank you. Thank you. That's all right. I guess I'll...
Thank you, Professor Hessick. It's always nice to know what's going on, and it will make it a lot more interesting for those of us who are following the work of the court this term.